Thank you very much, and good morning to everybody. I was saying to Professor Webster that when she invited me to participate in this event a year and a half ago, and I gladly accepted, little I knew that we will be still in the middle of trying to finalize copyright proposals in the European Union, and that it will put me in a position which is probably one of the most dreaded by all civil servants, which is to come to speak to a place where people want to speak about something that you cannot speak about. I'm talking about leaked copyright proposals, and nevertheless be able to speak about something that is mildly interesting for the audience. Therefore, as a disclaimer, I won't be able to take positions and discuss some of the leaks that, as far as I am concerned and the Commission is concerned, we don't discuss those texts are not there. But let me try to nevertheless speak about copyright policy from the perspective of Europe. And I think it's an interesting issue, basically because although copyright policies are complex and have become increasingly complex in all jurisdictions, I think we probably have an added layer of complexity in the European Union. And that complexity, part of it is structural, is because of what we are, the strange animal that the European Union is. Part of that complexity is the result of the steps that we have taken over the years, and now I'm talking about 25 years of activity in copyright at European level. So let me describe them and then try to at least discuss where can we go from here. Very, very fast as regards the challenges that we have because of the structure of the European Union, those are quite obvious. We are, at the moment, 28 member states, different jurisdictions. We have in some cases quite different legal traditions, and we are talking about an area of legislation that in some of our member states dates back to the 18th century. It is not the same to try to harmonize and make a common system in areas of legislation which are relatively new. You can take, for instance, data privacy or some aspects in telecommunications law as compared to other areas, whether it is civil law or copyright or others. We do have as well different policies in different member states on issues which are directly affected by copyright, whether we're talking about research, whether we're talking about education, whether we're talking about policies related to libraries. And we also have a different presence of the industries that rely directly or indirectly on copyright, that have an interest in copyright, whether in the protection of copyright or in the use of copyright protected material. And these are issues as well that do have, obviously, an effect in the shaping of policy at European level. And finally, and this is what is most important, the infrastructure that underlines the functioning of copyright markets is different in different member states. And what do I mean by that? Far too often when we talk about copyright, we look at pieces of legislation where there are rights recognized, exceptions recognized, tests for the application of the management of the right, enforcement of the rights, etc. But that is copyright on paper, and then there is copyright in reality. And there are many elements which are extremely important for copyright to work in practice, and that are different in different member states in Europe. What am I referring to? I'm referring to the functioning of the administration of justice and the functioning of the courts, the expertise in copyright in the courts of the member states. I'm talking about the functioning of collective management organizations and of the supervision of collective management organizations by the member states, including things like rate setting. I'm talking about the existence or not of structures that allow dialogue between right holders and industry, for instance, for things like setting private copy levies, or for agreeing between, say, for instance, publishers and universities in the use of content for academic teaching and research. I'm talking about contract law. And I'm talking even about the physical infrastructure. The discussion about copyright is not the same in some of our member states where basically online is becoming the main form of distribution as compared to other member states where that is not yet a reality. Remember, we're talking now about a very varied market, also from an economic development point of view. So that is the reality. That's where we live, and there is relatively little that we can do. But there is also a degree of complexity that is the result of the manner in which copyright has evolved in the European Union in the last 25 years. And having been, not in the full 25 years, for an amount of time in and out this process for some time, I think I can honestly say that probably we did not realize at the start of this process of harmonization where it was leading us. Now, I'm not saying that where it has led us is a bad place, but I'm trying to say that there are a number of things that have happened without them being necessarily the conscious choice of the legislator and the member states at the time of the taking of decisions. We started back in a very normal fashion, which was to complement the existing laws of the member states in copyright as regards, first of all, the protection of subject matter that were relatively new. The first directive that we did back in 91 was the software directive. So we were, as everyone else around the world, and remember we were as well at the times of discussions in the Uruguay round, was recognizing the protection of software on the basis of the assimilation of software to a literary work. Now, we continue in that pace to some extent, i.e. intervening in areas where there were new subject matter protection. Databases was another example, or new forms of distribution, communication to the public by satellite, cable, the Satellite and Cable Directive. But I think quite quickly, and maybe not in an obvious manner, we got into what I call the core of copyright. Already back in 92, in the directive that we recognized a rental right and a public lending right, we did start harmonizing related rights in Europe. We did incorporate the Rome Convention principles and made them applicable to all of the member states at the time. So we started saying, these are the rights of performers, these are the rights of broadcasters, these are the rights of film and phonogram producers. And these clearly happened big time with the 2001 InfoSoc directive, where at the time of the implementation of the WIPO 96 treaties, we do establish in a more horizontal manner the rights as well of authors. There we had, if you want, brought the core of copyright within the union level. And as the Court of Justice was to explain to us later, this had far-reaching effects that maybe we had foreseen. We did create some of the circumstances that afterwards are making our life a bit more difficult, such as, for instance, establishing a closed list of limitations and exceptions of copyright. We were little by little consolidated the member states together in the further evolution of copyright, but we cannot ignore that the diversity that I was describing at the beginning, including as regards the infrastructure for the functioning of copyright, remained there, and it is still there. And it is on the basis of this, if you want, organically grown body of legislation, which by now is 11 directives. It is on those bases that the Court of Justice, in particular after the InfoSoc directive, has been extremely active and has gone to some extent, but the Court of Justice of the European Union always does that, has gone to some extent beyond the simple interpretation of the law at European level. The court always interprets the law with a political objective, the political objective being the functioning of the internal market in this particular area of legislation, because that is the legal basis that we have to intervene. And it's nothing new. The court had already done it in the 1970s. In the Deutsche Grammophon case is the first time where the court says, we have free movement of goods in the union. You might have copyright that in its existence recognizes a distribution right, but the exercise of this copyright, you have to ensure the free movement of goods. Therefore, we are going to have exhaustion of the distribution right once a work has been put in circulation in the internal market with the consent of the right holder. But the court has become far more active in the area of copyright, and there have been seminal interventions which are not finished. I think we started probably by InfoPac, trying to discover what originality meant at European level. We've had, and we continue to have, the whole saga of the case law of the court as regards communication to the public, what constitutes communication, what constitutes a public, what it is, the concept when applied to hyperlinking. I mean, the famous case in this front is Benson, but we do have very important case law still to be made. Next one will happen on the 8th of September with a pending case, GS Media, which will go back to the issue of hyperlinking, in this case to content that has been put on the net without the authorization of right holders. What I'm trying to say is the court has been shaping the communication to the public right on the basis of a very simple article in union law which says the authors have the possibility to authorize or prohibit the communication to the public right, and that includes the making available. The same with other areas of law. So we find ourselves that the level of harmonization that you could say is already quite high has been made higher by the intervention of the Court of Justice. And just to complicate a tiny bit more the whole picture, whereas we have been going on and on saying we are doing this, we are intervening in copyright because of the internal market, i.e. the free movement of goods and increasingly the free movement of services, there is only a limited internal market effect in a number of our directives. Obviously, we do have internal market effect thanks to things like term of protection being the same, or thanks to the intervention of the Court of Justice for the distribution right, which has been after codified. But we still have big questions as regards things such as where does the act of making available take place, and also there is certainly no cross-border effect to limitations and exceptions. So where do we go from here? Where do we go from the situation where we are now, where clearly the room for member states to maneuver is become very, very small, and also almost in an unexpected manner. I'm going to give you just two examples very quickly of things that have recently happened or are pending that will illustrate my point. We have had relatively recent a case, the reprobable case, which was referred to the Court of Justice from a Belgian court, asking about the functioning of the reprography exception and the levy for reprography in Belgium. The reply of the court has been to that extent, but has also told member states, if you have systems in which collecting societies are organized in a manner where there is a share of reprography between authors and publishers, this is not compatible with EU law, which you might think is the right result or not, but definitely is a very difficult conclusion to read in our existing legislation. Or we have a pending case in front of the court sent by the French Conseil d'Etat as to the compatibility with EU legislation of the system that France had put in place or has in place to facilitate the digitization and making available of literary works which are out of commerce in France, which is based in a system that comes close to compulsory collective management, although you could say as well that is rather an extended collective management of the rights because there is a possibility of opt-out, and which we might find is going to be stricken down by the Court of Justice, at least on the basis of the opinion of the Advocate General. Not only France might found that the system they put in place to facilitate libraries and others digitizing out-of-commerce works, the system is not compatible with EU law, but it might be that the whole of the Nordic system that relies extensively on what we call ECL licenses is also put into question. Again, these are issues where all of a sudden member states find that what they thought they could still do is not possible because of the harmonization at union law. Where do we go from here? Where do we go from here? Also taking into account the speed of change, the speed of technology, and the structurally very slow way in which legislation at European Union can be built. I don't have a definitive opinion, and clearly this is now a complete personal opinion and nothing related to the position of the European Commission, but I think it's worth really thinking about this very carefully. We are really in a crossroad. And very often what people say, having gotten what we have gotten, is we have to go to a European copyright code. That is the next jump for many. I understand perfectly well that is very much loved by academics, but when you try to look at these issues as well from the point of view of the policymaker and having a look at how our member states and the markets work, at least I think it's worth discussing what is the alternative to a European copyright code. And I think one alternative that I think it's at least worth discussing is what about having a system that continues to have as an objective the functioning of a European internal market for copyright protected works and for the use of those works, but by also helping the better functioning of the national laws on the basis of the harmonization that we have in place. It's not a new revolutionary idea. The internal market has very often been built on a very simple system called mutual recognition together with cross-border effects of national legislation. Always very difficult, always contested by member states, but I think it is worth considering whether as regards certain areas of legislation we could not devolve some flexibility to member states while ensuring that the policy objectives, for instance, of limitations and exceptions are met and the cross-border effect of the legislation is already ensured. I think together with that, there is an absolute need to increase cooperation between member states as regards not only administrative cooperation, but also the judiciary. And I also think that we may need to start having some sort of guided development. The case law of the Court of Justice is so important in its application by member states that interpretative guidelines by the right means, which are always very much contested, but that is a form of intervention that will be very, very important going forward, in my view. I know that this seems to be a little bit against the current of farther and farther and farther harmonization, which is for the time being what we are doing. I'm not saying that we do not need to have a minimum level of recognition of rights and exceptions to rights present in all of the member states. I'm just highlighting a reality, which is we might need to recognize that a level of diversity will continue to exist in different jurisdictions in the member states, but we can continue ensuring the functioning of the European Union as a project by means not of everybody having the same laws, but everybody having the same objective, a level of harmonization that is sufficient, and a much stronger cross-border effect for both the exercise of the rights and the application of limitations and exceptions. And with this, and even if I have not said anything about any leaked text that may be on the table, and I will refuse to do so in the discussions after, I hope I have put on the table something that you think is worth discussing. Thank you.
Well, good morning. I feel very lucky that I have no leaked texts to worry about, although one is always at a slight disadvantage when working for the government and speaking to a group of academics, because it's impossible to be as opinionated or provocative as you might want to be. So I'm going to approach this in a slightly different way. Let me start by just talking about the environment we find ourselves in today in terms of copyright policy. As everyone knows here, increasingly copyright is the subject of public discourse, not just academic discourse or policy experts. And I've been thinking, as I work at the Patent and Trademark Office now and look at the wide range of IP issues, that the attention given to copyright these days is comparable in its intensity only to the access to medicines issue. Now, of course, for copyright, we're not talking about life and death issues, but we are talking about something that is part of the fabric of everyday life for most people these days. We now have a much greater range and number of participants in these discussions as we have an increasingly complex chain of distribution of copyrighted works. And those participants include consumers in new ways, because consumers now are not only active, but they are very influential participants in the discussions. First of all, they're influential in their role as creators themselves. When you look, for example, at UGC and that whole world that's blossomed, they are influential in their role as users, where they can make a much greater impact on markets than they ever could before. They're influential in their role essentially as distributors and publishers in their own right over the internet. And last but not least, they're very influential in their role as political players. They've got a much louder voice than they ever did before. So the result is that copyright is under great scrutiny, and it's being questioned all the time, I think at an unprecedented level. Now, of course, historically, we've always had regular updating of copyright law to respond to technological change. Copyright started with the printing press. It continued through radio and television and all of the various technologies that have developed over the centuries. But I do think that there's a qualitative as well as a quantitative difference now, and the discussions are more, the debates and the challenges are more constant. They're more in a very intense spotlight, and they're noisier. There's more voices, and they're louder. So I think these are positive developments in many ways. They lead to increased perspectives and participatory democracy in this area, but certainly in the United States, it makes legislative change ever more difficult. So as you'll see from my description of what's happening in the United States, there's a tremendous amount of activity and discussion, but we are not moving very fast on the legislative front. So in a way, there's a paradox. There's more pressure to change constantly than ever before, and at the same time, there's less ability to do so. Meanwhile, at the same time, markets continue to evolve. The private sector isn't sitting there and waiting for legislation or waiting for government to act, and the markets are evolving in ways that may overtake the policy discussion and alter the landscape that feeds into it. And I do think a lot of this is positive because you're seeing responsiveness to consumer demands. Now, since the early 90s, at the dawn of digital technology, we've been asking ourselves around the world whether copyright is still, to use an English phrase, fit for purpose, and especially focusing on how it should be updated to respond to digital technology. So I will, of course, focus on the United States, but a lot of these discussions are proceeding everywhere. And the green paper that was issued by the Department of Commerce's Internet Policy Task Force, IPTF, in 2013 gives an overview of all of the various waves of updates in the United States and also at the international level. And what we've seen is that there was a big wave of activity in the 1990s, including the 96 WIPO Internet Treaties and the Digital Millennium Copyright Act, or DMCA, in the United States. Then in the decade following, in the first decade of the 21st century, the pace slowed, and we had a few updates, notably in the US, to our exceptions, for example, digital distance education, the Chafee Amendment for the blind and visually handicapped, and the library exceptions. But then in this decade, there have been renewed calls for more change. We saw a big push to do something on the enforcement front, which faltered in 2011 and 2012. And of course, I'm talking about the notorious SOPA, PIPA introduction, debate, and death. and the ACTA agreement as well. So you can debate the merits, but one thing that was certainly clear is that the voices of the public were heard very loud and clear and had a tremendous impact on what was happening. The latest phase now involves an ongoing congressional review of the Copyright Act, various continued activities of the Department of Commerce task force, and a plethora of Copyright Office studies. In fact, we're so active in the United States and there's so much happening that we're beginning to hear loud complaints from stakeholders who are saying they're just overburdened with the number of submissions they keep having to make to various different parts of the government. So I think all the analysis that this has produced has been very valuable because it's increased understanding of a lot of issues, and that in itself is worthwhile. But we have seen very little concrete outcome at this point. So let me talk a bit about the state of play in the United States. So I think what we saw was, as has been true elsewhere, a combination of, first of all, a bit of a revolutionary movement to throw out the whole system and replace it with something new. We also saw a more aspirational desire, and this was particularly expressed by the Register of Copyrights in a speech in an article called The Next Great Copyright Act. And that aspirational desire was to build a more cohesive and elegant system instead of the one we have, which has developed through a process of accretion and might be described as a bit messy. But those initial impulses at this point over the last few years have really moved toward a narrower and more targeted approach. Now, I think that's partly because there's general feeling that the basic framework in the US, the balance of rights and exceptions, is fairly stable. So we've seen people start to focus on 4 broad areas. One is adjusting existing exceptions rather than looking at new exceptions, but adjusting them to accommodate the latest technologies, so continuing the work that began earlier. And that includes looking at the exceptions to anti-circumvention rules. Now, the discussion is rather different from the EU by definition, in part because, well, obviously we don't have the issue of member states' subsidiarity, all of those questions, but we do have the fair use doctrine in the United States, so a lot of the discussion now is about the relationship between specific exceptions and fair use, and what's interesting is there's developed some opposition in what you might call fair use communities, like the library community, to updating specific exceptions because they would prefer to rely on fair use because they like the way the courts have been interpreting that doctrine. So you don't necessarily see the communities you would expect to be lobbying for updates to their exceptions. That's not necessarily happening. And there's instead more discussion about what is the relationship between fair use and specific exceptions. The second broad area is dealing with works that you might say don't really fit into the copyright market system and cannot be licensed individually from a practical perspective. And of course, I'm talking about both orphan works and some of the issues involved in mass digitization, including out-of-commerce works. Third general area is looking at ways to improve our licensing structures. And then finally, how to control online infringement. Now, those last 2 issues dealing with licensing and infringement, I think are equally important to the questions about the scope of rights and exceptions. But what's interesting is they do not necessarily involve legislative approaches, or at least not purely legislative approaches. They're issues that can be addressed through many different initiatives. And then I just wanted to mention one area that I think is sort of looming on the horizon and increasingly important, but not yet really being focused in the US debate, and that is the complex of issues that have to do with the global connections in the copyright system. And so I'm talking about cross-border exchange of works, exhaustion, international exhaustion, harmonization, and the goal of increased harmonization, and choice of law questions. All of them incredibly important, not yet really on the table in Washington as a major item of debate. So let me just give you sort of a quick tour of where things stand. We had, between 2010 and 2015, the development of a number of voluntary best practices where stakeholders got together and tried to work on ways to control online infringement, and that was very much encouraged and facilitated by the White House through the IP Enforcement Coordinator. And that work still continues, but there was this flurry of activity during that period. In 2013 was when the Department of Commerce issued our green paper, and in addition to looking at all the steps that have been taken so far to update copyright to deal with digital technology, we also identified what issues were currently still in need of attention, and many of those were under consideration already by Congress and the Copyright Office, and I'll talk about what they're doing. And then we also identified a few others that we would pursue in the Department of Commerce, and some of these were non-legislative in nature. So that included bringing stakeholders together to look at how to develop best practices to improve the operation of the notice and takedown system, and also looking at the role of government and what steps we might be able to take to facilitate the development of the online marketplace. And so we've been pursuing those as well. Starting in 2013, there's been this extensive congressional review. The chairman of the House Judiciary Committee announced that he was going to be looking at all aspects of the Copyright Act to see what needed to be updated. They've held a long series of hearings, they've had private meetings, they've had listening tours around the country. It's really been an exhaustive range of issues. The Copyright Office has also engaged in, as I said, a large number of studies, most notably one on orphan works and on mass digitization. And they recommended, again, pursuing the approach of having a limitation on remedies for those who go ahead and use orphan works after having engaged in a diligent search to find the owner. They also recommended, Maria talked about the extended collective licensing that exists in parts of Europe. They're interested in initiating a pilot program to use an ECL approach for dealing with mass digitization. They had a study that recommended establishment of a small claims court for smaller copyright disputes. They issued a lengthy and comprehensive report on music licensing. It's very specific to the United States system, but they provided multiple recommendations on how to improve what is really in the United States a very complex and unwieldy framework for music licensing that we've developed, historically by accretion and really could use some overhaul. And then last but not least, during that time period, they had a study on the making available right, which did conclude that the right does indeed exist in the United States. In 2016, this year, early in the year, in January, we issued in the Department of Commerce a white paper which addressed 3 policy issues we had identified for attention in the green paper. One was the legal treatment of remixes in the United States, a form of user-generated content. Second, exhaustion, or the first sale doctrine in U.S. law as applied to digital transmissions. And third, looking at statutory damages and what their appropriate calibration should be in cases involving individual file sharers and mass online services. And the recommendations were that no statutory change was needed for either remixes or exhaustion, that several amendments were recommended to give courts both more guidance and more flexibility in assessing statutory damages. And then we made some non-legislative recommendations again, particularly focusing on the development of stakeholder guidelines and best practices to achieve better clarity in the law. And we also supported the idea of a small claims court. Especially, we thought it could be very helpful with some of these file sharing cases, among others. And then just to mention one other thing, we did send the Beijing and Marrakesh treaties to the Senate for ratification and implementation, along with proposed implementing legislation. So what do we expect this year? On the legislative front, the House is promising to put together a package. They've been very coy on what will be included in the package, I think not because they're being secretive, but because they still don't know for sure. It's likely, if I were to guess, the topics that seem most likely to be included would be something on music licensing. Whether it will be comprehensive, looking at all the issues the Copyright Office identified, we don't know. They could try to address just some things that are less controversial in that mix. Probably something on orphan works, which came very close to passing 10 years ago, and I think they will take up again. Possibly establishing a small claims court, which does not at this point seem terribly controversial. Maybe something on Copyright Office modernization, and that really has to do with making sure the Copyright Office has adequate resources to do its job well, including to set up more of a state-of-the-art database of registration and recordation information, and also possibly to guarantee it more policy independence. And then we're hoping we may convince Congress to include some of our recommendations on statutory damages and on treaty implementation. So we shall see. The Copyright Office is still also engaged in a few other studies which could lead to legislation. Probably the most sensitive and controversial is one on the DMCA, on the ISP safe harbors and the notice and takedown system. And just as there's a lot of sensitivity in Europe about reopening the e-commerce directive, there's a lot of sensitivity in the US about reopening Section 512, concern on all sides about what happens if it's reopened at this point. So we'll see what the office recommends. They're also looking at our anti-circumvention law, in particular at the rulemaking for exceptions, and focusing on the process and how it works. They're looking at, and I find this one particularly intellectually interesting, copyright and software-enabled consumer products. What's that intersection going to look like? And again, their pilot program on extended collective licensing for mass digitization. In the Department of Commerce, we're going to take forward some of our work as well. We're going to continue some stakeholder discussions on how fair use applies to remixes. And on consumer messaging. What are consumers told when they buy content online, and how do we make sure they're aware of what they're permitted to do? And we're also going to continue to work on what the government role can be in facilitating the online marketplace, focusing on incentivizing the increased use of standard identifiers, because the database issues have become increasingly of interest. So just to conclude by saying, meanwhile, we're seeing continued private sector efforts in many respects, again, which I think are equally significant. The private sector is working on ideas for controlling online infringement, I think in part with the goal of diminishing the perceived need for legislative solutions, and this can include taking forward the voluntary best practice approach, or what is sometimes called the follow the money approach. It includes some individual agreements. We've seen some between some of the big copyright industries and individual online services or platforms in this respect. There's a lot of work being done in the music licensing space. We've seen, for example, an agreement that provided the equivalent of a broadcasting right in sound recordings, which doesn't exist legislatively. Again, an attempt to minimize government involvement. The development of databases of ownership information to make licensing smoother and easier. And then again, more and improved consumer options in the marketplace, which can help relieve the pressure on legislators and also provide more alternatives to illegal offerings. So I would say I do see a trend toward more private sector activity, and in some ways a lessened role of government. I think the government role is moving more toward providing frameworks, legal frameworks within which all of this activity can go on, providing tools to the private sector, and then, of course, providing a very critical oversight function to make sure that the public interest is respected as all of this activity continues. And I think, in a way, it's pragmatic because, as I've said, legislating in this area is difficult, in particular in the United States, where the administration doesn't control Congress, and where Congress can be paralyzed by dissension and public outcry. And then, of course, you also have the fast pace of technological change and the very complex needs of the digital marketplace, where it can be easier for the private sector to respond to these and to keep up with them. So finally, just to say, I think internationally, I see three dimensions in which there's sort of overarching tensions playing out. One is the desire for flexibility versus the desire for certainty. Second, the entrenched framework concept of territoriality, which our whole international system is based on, versus a desire for harmonization. And finally, the last item I was talking about, the relationship between regulation and private ordering and the back and forth between them. But of course, the relative focus and the context are somewhat different in different jurisdictions. So you see, for example, in the European Union, a lot of attention these days to the territoriality versus harmonization issue, whereas in the United States, perhaps more attention to the regulation versus private ordering aspect. So I think I'm out of time, and I will stop there. Thank you very much.
So I'm not a government official, so I guess that means I get the fun job. This is the topic that Beth gave me when she first invited me to speak here. An optimal copyright policy for the 21st century. So just a little job. Yeah, that would be great, thanks. She didn't actually tell me whether it has to be achievable, but as the academic on the panel, I guess I'm entitled to push the envelope a little. Just to lay a little bit of groundwork, there are lots of good news stories around our creative sectors, right? There's lots of creation, there's lots of money. In a lot of sectors, revenue is stable or up. It's never been easier to create. It's never been easier to reach a global audience. So this is all the good news story. On the other hand, we have the bad news stories or the problems. We do have declines in some areas. We have the perceived value gap. We have the perception that creators aren't benefiting and that the public sector may not be benefiting as much as perhaps they could. And we also have the fact that copyright has a bit of an image problem. So this is the infographic that was produced by the Australian Productivity Commission in launching its draft report not long ago. Doesn't take much to see what they think of our current copyright regime in Australia. So we do have an image problem. And there's a reason we have an image problem, because copyright has a lot of dumb, confusing rules in it. It really does. If we were designing an optimal copyright policy for the 21st century, it wouldn't look a lot like what we have today. We wouldn't have 100 plus years of exclusivity in selfies. This really doesn't make much sense. And there's no lack of proposals for improving things and making the sorts of marginal improvements that the previous panellists have discussed. Now, I am not going to try to give you a silver bullet here today. That's not really going to happen in 20 minutes for the entire copyright system. What I want to do is talk a little about, I want to give you some tools for assessing some of the proposals that are going around. And I'll give you some of my views as we go along about how some of these principles might impact on some of the proposals we're hearing for improving copyright at the moment, and maybe throw in a few provocative ideas of my own. Now, the principles I'm going to be talking about today are not comprehensive. They're not the only things that are relevant to copyright, right? Incentives for creation are relevant, freedom of speech is relevant, transaction costs are relevant, economic efficiency is relevant. The sorts of considerations I want to put out there today, though, are the ones that I think are sometimes missing from some of the current discussions. Okay, so the first principle I wanted to talk about is that copyright needs to be designed in the public interest. I actually debated whether to include this principle, and the reason I debated is because it seems pretty obvious to me. But when we have discussions about copyright reform at the moment, you do hear a lot of claims that copyright is all about creators. And of course creators are important. Or it's all about cultural industries, and of course cultural industries are important. But they're not the only important things. So I think this idea that copyright needs to be designed in the overall public interest is an important one. And I should emphasise I'm not talking here about public interest as in users who want to get stuff for free. I'm talking about the collective interest, That is the interest that what people would choose if they saw clearly, thought rationally, acted disinterestedly and benevolently. Exactly how we have our copyright reform debates today. If you are struggling to think this way, and I struggle to think this way, as both a user and a producer of copyright material, you could try the old philosopher's device, the veil of ignorance. Imagine the copyright rule, or imagine what you would think about the proposal if you were behind a veil of ignorance, if you were designing the rules that were going to apply in the society you're going to live in, but you could be a creator, you could be a rich person, or you could be a single parent on welfare. And thinking in these terms does tend to focus the mind. It doesn't lead to thinking about the most minimal protections you could possibly have, because you might be a writer. But if you could be a single mother on welfare payments, worried about the education of your child, it tends to focus the mind on things like access, public libraries and public schools. And a system designed entirely in favour of user pays or extracting the maximum premium from copyright material suddenly looks a whole lot less attractive. Anyway, try it sometime. It's an exercise I did for a book recently, and it's actually quite useful in making you sit back and reassess your own prejudices or biases. All right, the second principle I want to highlight that I think we need to pay a bit more attention to in the current debate is that copyright could do a better job for human creators. It really could. And that means two things. Yes, it means making sure that copyright rights are real and effective and can be transacted around, but it also means recognising the interests of human creators, authors, musicians, etc., are not coextensive with the interests of copyright owners or the production parts of the industry. Now, this matters because not just because promoting creators is an important rationale for copyright going beyond the purely economic and going all the way back in history. It also matters because long-term reforms are going to fail if we don't pay attention to this, if we don't pay attention to the human side. For as long as we are getting survey results that say that Australian authors are earning something like $9,000 a year from their writing, people are going to be unhappy. And they're going to be unhappy on both sides because that sort of result in a survey justifies either side of the reform debate. On the one hand, it will be used to indicate that the copyright system fails authors anyway, so why shouldn't I just infringe? On the other side, of course, it justifies that we need stronger copyright, longer copyright, more rights, whatever. So if you actually want copyright reform to succeed, you should be paying attention to human creators and how they figure into everything. Now, if you understand cultural economics, hi Ruth, you will understand that this is easier said than done, right? Because more people want to be musicians and writers than will ever succeed. That puts creative types at a disadvantage when dealing with producers and distributors. This is exacerbated by high concentrations in production and distribution industries. And many creative markets exhibit blockbuster dynamics, where the lion's share of attention and rewards goes to a small number of people. And not all worthwhile cultural and information products will succeed in popular markets. And with some very notable exceptions, creators are often not particularly organised to act collectively. So I'm not naive when I say this. But there probably are a few things we can do to level the playing field. And some of these are being discussed in Europe, I understand. Ex-post adjustment mechanisms for really super bad deals where someone sold out very early on in their career is one such idea. Might even be a good one. It's good to see something being considered for individual authors. So is the idea of demanding more transparency from collective management organisations regarding how the spoils of copyright are divided. We can also think even more creatively if we want to be provocative. As I said, I'm the academic. We could insist, where there are demands to extend copyright in any way, we could insist that those extensions go to the human creator. Why? Because the producer didn't bargain for them in the first place. It's a windfall. And if we want a windfall to go anywhere, where do we want it to go? We could try setting standards for contracts. We could try applying use it or lose it principles or reversion rights. We could, but perhaps most importantly, and I should say, these ideas are less radical than they seem. Most of these come from history or from certain countries who have aspects of this in their systems. These are not weird, way out ideas. And as I say, some of them have been considered at various times. But perhaps most importantly, it would be nice to see a change in the discourse to focus on human creators as distinct from copyright owners when we are talking about reform. For example, I would like to see organisations, I would like to see institutions doing reform insist that those who are arguing for copyright reform show in a concrete way how human creators will benefit from the reform. So if Europe is considering requiring user-generated content sites to license music, I would like to know how much of that money will go to performers and creators and composers. And whether the Commission has considered creators as a stakeholder group perhaps separate from copyright owners. Maybe we need an author impact statement for copyright reform. In the Australian current debate over parallel importation of books, there's been a lot of insistence that the Australian publishing industry is very important to Australian authors, and I don't doubt that that's true. But there's also studies suggesting that local publishers' direct support for Australian writers is quite limited. And I wonder again if we could press into that and see how much parallel importation genuinely helps creators and authors as opposed to publishers. If you are dealing with voluntary systems for copyright enforcement or memorandums of understanding for notice, it's notable that many of these have been agreed between big copyright owners and big intermediaries. What about independent creators? How do they get a look into online enforcement? So I'd like this to be more part of the discourse, and I think there's a very real reason, if we want reform to succeed, to get it in there. Okay, the next principle I think we need to consciously think about in copyright reform is the need for differentiated protection and how we do it. We sort of pretend in a lot of copyright law that all copyright matter is created equal, well, not really, but we know that, of course, there's all sorts of different materials protected by copyright. There's the stuff that is really valueless, yesterday's email, protected because, of course, we have no real innovation threshold in copyright. We know that we have, core copyright works. We have some copyright material that's performing an entirely different purpose. We have works that have non-commercial benefit or value, like government documents. Now, these call for different kinds of regulation. We also know that over time, works change in their importance. So some of those commercial or core works are going to fall away to being valueless. They're going to go out of commerce. We know that some of them will be of longer non-commercial benefit than commercial benefit. But we regulate sometimes as if these were all one thing, which of course makes no sense. Now, if you are a copyright expert, you know that I am massively oversimplifying because we already do more than you might think to differentiate protection. But it's interesting looking at the tools that are used to do so. If you're going to try and differentiate, you can try to write detailed rules into legislation. We will give less protection to certain kinds of photographs, which historically we did, because we thought of them as lesser forms of art, so only gave them 25 years or so of protection. Or you can try to build some standards in. And in the US, fair use does this to some extent. So in determining whether a particular use should be allowed without payment or permission, US courts can take into account the age of work, the impact on the copyright owner's market, whether it's being exploited. So we can do within the court system and within a standard like fair use some of the differentiation that makes copyright make more sense. That is the benefit of a standard. And it's something we need to think about in Australia. But we could think about other things too, right? So we could have exceptions that apply by default to older works. We could say anything created before 1950, this exception automatically applies unless you opt out. Be another way to try and help bring some of those out of commerce works into the world again. We could confine infringement or remedies in cases where the use does not in fact compete with the copyright owner. We've done this in trademark law for years. So there are various things we could do, but we need to think about this again when we're looking at copyright reform, and we need to evaluate the best tools to achieve the kind of differentiation that will make copyright make more sense. Okay, the fourth principle I want to mention is that the rules need to allow for innovation from outside. Now, this is where we get sensitive, right? Because this brings me to the battle royale of copyright law. This is the interaction between copyright and technology. And we've already heard a number of comments, I guess, from Shira and Maria about this idea, these issues being brought up by the interaction between copyright and technology. If you're following this debate at all, you'll know that there are a lot of proposals floating around based on the idea that anyone who uses copyright material as an input to a service or product should get a license. And we also see arguments that unlicensed uses, say in the context of user-generated content, stifle legitimate licensed services like Deezer or Spotify. Now, the argument that the rules that have allowed user-generated material to arise, the safe harbours in particular, have stifled technological innovation, of course defies our lived reality. And as Ruth Towers has shown in her work, new ways to distribute and consume content have not tended to come from within the content industry. They've tended to come from outside, whereas the content industry being responsive and starting to license things after a while. I mean, think about it, you know. Does anyone in this room really think that if the not yet established YouTube had rocked up proposing a business model of user-uploaded videos, some of which might have music, some of which might have lesser or greater quality, that the music industry would have embraced that idea and then, you know, wanted to commercialise that and take a cut and end up getting $2 billion a year from that sort of monetised use? And I invite anyone in the room to take a stab at imagining what a licensed YouTube might have looked like. Probably not much like the YouTube we have. If you remember, iTunes, right, originally had digital rights management as a result of its licensing arrangements. What's the other one? No, I've lost it. One thing that concerns me a little about some of the proposals that are floating around, again in Europe at the moment, is a focus on established players. So newspaper publishers or broadcasters. And this idea that there should be, you know, better mechanisms, say, for licensing for broadcasters for retransmission, which, you know, in and of itself, not necessarily a bad idea, although I haven't thought about it in any great detail. What concerns me is that a lot of these proposals do focus on the established players, and they don't, you know, there aren't proposals to extend these to industry outsiders. And again, I think that if you are thinking about reform in this copyright technology space, you should consciously be considering if you're proposing a system to benefit certain industries, existing industries, then you think about what the impact on outsiders is, and you think about whether you can extend the same privileges to other forms of technology. Speaking as an Australian, you know, where we developed an exception to allow for taping of home television, but omitted to draft it properly to allow for cloud taping. So as long as you've got a box in your house, it's good, comes under the exception. If you want to have cloud storage of stored TV, no chance. And again, here's another thought. The rules which often facilitate innovation in our copyright system have often been standards-based. Either the Sony Betamax decision kind of safe harbour for technologies with substantial non-infringing uses, or again, fair use. Right? Because a firm that is wanting to make out a fair use case has strong incentives to minimise their impact on copyright owners' markets. Google was able to make out a fair use case for Google Book in part due to the many precautions they took to protect right holders. So, you know, employing strong security, showing only snippets, working hard to ensure that snippets couldn't be strung together to a book, making it possible to find places to buy the book, etc. Similarly, the Hathi Trust, which provides copies for basically researchers to do text and data mining, and for the visually impaired, they also adopted security precautions and took steps not to provide texts that would substitute for commercial sale. I think sometimes we forget the innovation-inducing nature of standards like fair use, and in particular the copyright-friendly innovation-inducing standards. And the final principle I want to mention is copyright should not be a system where benefits are for owners and burdens are for everyone else. That is kind of the system we have at the moment, right? Because under present rules in copyright there is no obligation to register, no obligation to give notice of the right, no obligation to make it easy for prospective licensees, and no obligation to publish the material. So you can lock stuff up for 100+ years while providing no obvious tangible benefit to the public. The questions of distribution of benefits and burdens is the issue that has held up a lot of reform around enforcement in Australia. Right? Who pays if you want to have new enforcement systems has held years of negotiation around online infringement. And you can't help but wonder if there was an understanding that burdens ought to be shared, and not just, burdens ought to be shared by everyone, that perhaps those negotiations could have gone forward a bit better. Or to go back to the EU's ideas around user-generated sites, suggestions that I've seen to date look like they might impose a lot of burdens on sites with not much obligation to assist or cooperate on the part of copyright owners. Very vague suggestion that there should be cooperation. So those are my, I'll skip that because I'm running out of time. So those are my principles. They're just tools or thoughts that I think should be being considered in the copyright reform debates. And they're the ones that get lost because copyright reform has historically been so much about big negotiations or big fights between large sort of industries. The voice of, creators and these ideas about sharing of benefits and burdens haven't made their way into most of the reform proposal documents I've seen. Or if they do, they're in marginal ways. If we think about creators, it's at the margins around, fixing the contracts, and not, if we're going to extend rights, should those belong to creators? And I think if we bring some of these ideas into the discourse, it might make a lot more sense for a lot of people beyond, the copyright elite who are involved in negotiations day to day. So they're just some provocative ideas. I look forward to discussion of the details. I'm happy to talk about how they apply to any of these detailed proposals. And if you're interested in any of these ideas ongoing, I do have a book. Yes, I'm plugging shamelessly. This is what if we could have reimagined copyright, which is where a colleague of mine and some other colleagues put together some chapters where we did try to imagine what copyright might look like in the public interest. Thank you for your attention.